So this session will clarify youth rights across system, including education, healthcare, and child protection, and examine where legal protection exists and where advocacy is required. In this session, we shift from understanding status to understanding right. Even if someone's immigration status is unstable, they still have rights, and those rights must guide how system responds. Knowing where protection apply and where they don't allows us to support better young people navigating complex systems. And I am pleased to to mention our speaker today, Emily Chan, staff lawyer, community development, justice for children and youth. Please join me welcoming Emily.
Hi, everyone. Is the mic in a good position? Okay. So this is my agenda. We're going to speed through some of it, especially as it overlapped a little bit with the CASA slides. CASA and JFCY have worked in partnership for quite a long time. And at one point, I think a lot of our slides were like consolidated, and now they've been split up again. But I'm going to cover kind of our concept of children's rights. I'm also going to talk about other child and youth services that haven't been covered to delineate so everyone understands the differences between the different organizations. There's often a little bit of overlap in services, but also some very key distinctions that are important. I'm also going to talk about Legal Aid Ontario and the legal clinics and how that's structured, so there's a good understanding there. And then I'm going to talk about our clinic, what we do, what services are available, and kind of where we sit in that space. And then the second part of the presentation will be focusing on very specific children's legal rights, a little bit similar to what Esther and Sarah did a little bit earlier, and hopefully there'll be plenty of room for Q&A. Again, these slides will be made available to you, so after the program, and we'll probably, if there's some questions that don't get answered, but they end up coming to us individually or they came through the online, we can try and put that together, answer those together in email back out to you when the slides come to you. So that might work well. So kind of a overall challenging questions that I like to pose for you to think about is, how do the unique vulnerabilities of young people, including their dependents and adults, and the call for special protections influence our behavior? So we protect our children, we like to protect our nieces and nephews and all the children that we know, but how does that influence kind of their stance when they're looking to have their rights respected? So the next question is, do we impose our own views instead of taking the rights approach? Third is, are young people held to a higher standard than adults? Do young people have a right to make mistakes? Obviously, we don't want them to be making mistakes that are, long-term harmful, but at the same time, lots of us make daily mistakes, and we come out fairly unscathed. So young people should be permitted to do some of those things as well. I have a little question. There's like World National Children's Day, so it's November 20th. It's the anniversary of the UN Convention on the Rights of the Child. So those are some very fundamental principles that we work under. So Article 2 of the Convention says, there should be no discrimination for any reason. Article 3 is best interests is the primary consideration to be taken. That is something that we've fought for time and again in the court system to have that recognized, and it has come through in many cases. So we're pretty happy to see that happening through the court cases, that best interest of a child is taken as a primary consideration. Article 5 is about us. We should be giving appropriate direction and guidance so they can exercise those rights. Article 6, which impacts, especially in the precarious immigration status venue, is the right to life and maximum survival and maximum development. And for us, development includes school. Article 12 is the right to be heard and given a voice in all the decisions that impact them. As Sarah said earlier, they're all connected. These rights are inherent and they're indivisible. The only catch is, although we are signatories to the UNCRC, the UNCRC itself has not been adopted across Canada in all areas of law. So if it's not listed in legislation and it hasn't been put through case law where a court has said this is now part of our law, it doesn't exist in that venue. So, for example, the Youth Criminal Justice Act has in the preamble a recognition of the UNCRC. We don't have that same recognition in other legislation. The Education Act does not refer to the UNCRC, for example. So that's something to consider when we're in the court space and we're advocating. Obviously, we push for the best interests, we push for the convention rights, but at the end of the day, at the back of our mind as lawyers is what would actually happen if we took this to court? Would the UNCRC stand? Are we going to try and make it stand? I alluded to this already, like our role as adults. We have to recognize children and youth as individuals, personal agency, different personalities, and they hold all those inherent rights. We want all their views and preferences to be heard, but we have to make that possible. We have to be able to explain things in a language that they understand. We have to give concrete examples if that's what's required to make the understanding exist. We have to understand that they will change over time. In the immigration context in particular, we talked about years. It takes years and years and years to get an application through the system. So if you imagine that a 15-year-old puts in an application and they don't get a decision until they're 25, that's a very long time, and lots of development will occur during that time. So we have that obligation to support them, make sure they're involved, make sure they're consulted, give them choices when that's available, and we are responsible to safeguard their best interests. Some tips. CASA already covered some tips. There's a little bit of overlap because we have the same belief systems around equal treatment. So please adhere to all your regular professional and ethical obligations as you would with an adult, as you would with a young person. Check your assumptions. Try to understand the context of that individual child life because they may come to you as a family unit, but that doesn't mean that they have all the same lived experiences as the adult that they're with. Try not to judge them. Their feelings are their feelings, and it's due to the experiences that they've had. Be engaged to gain their trust. Gaining trust is tough. Listening is a key part of that. Outlining at the front what your confidentiality requirements is really important, because if you do have to share some information at some point, if they've been warned, you're not going to lose that trust. But if they haven't been warned in advance and they share something with you that you then feel that you have to share with someone else, it's over. You're never going to get their trust back again. So that's part of explaining everything. Who you are, what your job is, if they're part of a family unit, what you feel your obligations are to them individually, as well as them within the family unit context. Accommodations are huge. A lot of people talk about neurodivergency, and I think there's a lack of understanding across legal professionals and others about what that means. And so to us, what it means is you need to talk to that young person and find out what they need. Are they understanding what you're saying to them? Are there other ways that they will understand better? Do they need time and space to write things down? Do you need to write things down for them? Do they want to draw something beside what you wrote so they can remember what happened? And giving them an opportunity to come back, asking the questions, maybe again and again, for further understanding, try to explain things in different ways, just to make sure that everything's understood. We encourage our clients to ask for breaks, or we force breaks, just because a lot of the clients that we speak with have a lot of trauma in their backgrounds, and that it can get overwhelming really fast. And so it's to prevent a bit of a shutdown, but also to give them time to think a little bit more about what they actually want to say to you, things they may have forgotten. I'm like that. I forget things, so I have my slides. I'm going to remember what I'm going to say today. But if I didn't have my slides, I would probably go home and all night think about, I forgot to say this, and that. So turning on the other youth services that a lot of people do know about. So Office of the Children's Lawyer was mentioned earlier. They are a Ministry of Attorney General law office. They work in very specific contexts, custody and access, child protection, and on the civil side, civil lawsuits, estates and trusts. So they have these two pieces. One where the child is in a family context, the other one is kind of in the property context. So if in the property context, if somebody were to pass away and there's a child involved, then the OCL would get notice of that. In the other context, with the parenting and the access and the decision-making and child protection, that's when the OCL gets notified, they get appointed. So they're not generally in a role where you can call them and ask for representation. So in a divorce proceeding, for example, and there's parenting decisions to be made, what would happen is one of the parties, which is the parents, not the child does not have party status, cannot appear in court on their own, asking for things. They can ask that the OCL be appointed to represent and meet with the child to express what they want. They have in-house, they're located in Toronto. Their home office there's about 20 lawyers and 20 social workers to do assessments. And then across the entire province, they have fee-for-service lawyers and fee-for-service social workers. So that's how they manage all the work in all the courthouses across the province. The Ombudsman Child and Youth Unit is different, a whole different body entirely. They're also a government body, but they replace the Ontario Child and Youth Advocate. So every province and jurisdiction in Canada has a child and youth advocate office. It's an office. It's not one person. We call the head advocate the advocate, but then there's a body. So our Ontario Child and Youth Advocates office had about 80 staff in total, and it was replaced. So Ombudsman Ontario has different units, and child and youth is one of them. They take complaints. You can do it online, you can call, they investigate, but they have very specific mandates, and I've listed them there. It's also on their website. CASs, foster homes, group homes, secure treatment, youth justice facilities. In the education context, we have school boards, colleges, universities, loans, as well as health, CAS. There's a bit of an overlap in there. Social and development services, and the OCL itself. So if there's a complaint about their OCL lawyer, that's where a young person can go to make that complaint. So they have investigators and early resolution officers, and they have about 25 of them in the Ontario Ombudsman's office, focusing specifically on these things. So sometimes they'll be like they can't do the direct legal representation, for example, to get access into schools. But if they're being, but they may be able to look at some complaints and some investigations, may be able to have some conversations. They aren't necessarily lawyers. They maybe have legal background and legal training, but they're not going to be acting as counsel for the young person, not the same way the OCL does, and not the same way our office does, not the same way Esther at CASA would. So Legal Aid Ontario is a separate body entirely, and that's been brought up. So they are funded to provide certificates to the private bar on one side, and on the other side, they fund the legal clinics. So the certificates are when someone makes an application, says, I am facing this particular legal situation, I have low income. They get a certificate from Legal Aid, they take it to a lawyer who has their own office somewhere, and the lawyer says, okay, I'm going to represent you on this certificate. The person who has the certificate doesn't pay. Legal Aid Ontario pays that lawyer directly. So the lawyer accepts the certificate as how they're going to get paid for their services. In the legal clinics, the ones that are funded by Legal Aid Ontario, there's two different kinds. There's the general ones and the specialties. The general ones are neighborhood-based or whole areas. So Hamilton has one clinic with multi kind of satellites to cover Hamilton. But in Toronto, we have, 20 or more of those clinics that cover the different areas. So I gave an example. So Neighborhood Legal Services is Toronto Downtown East. And on their website, what I found is these are the areas of law they practice. So housing, social assistance and income security, immigration, employment, human rights, and some notary stuff. So they don't do everything. And lots of clinics won't be able to do everything. So checking in with where the person lives and the neighboring legal clinic to see if services exist would be a starting point to figure out. Sometimes it's not listed on their website. Sometimes you'd have to call them to find out. The specialty clinics, lots of them are provincial mandates, and they do different things. So I just listed a few. There's, I think, around 20 specialty clinics. Community Legal Education Ontario is one I highlighted there. We have a person here, Misha, who's waving. She works at Clio, and they're the ones who do the publications and then the steps to justice that CASA mentioned earlier. And then for the full list of clinics, I've put a link on the slides that you're going to be receiving. So we are one of those specialty clinics. We have a provincial mandate. We were incorporated in 1978 as the Canadian Foundation for Children, Youth, and the Law. So imagine saying that when you answer the phone. It's a bit of a mouthful. Nobody really liked it. So we operate as Justice for Children and Youth. That's what we're known to in the courts. That's what we list as our names on everything. We're independent. We are a registered charity. So all the legal clinics do operate independently with their own board of directors. Our services are to young people under 18 in the province, and we have one lawyer dedicated to providing services to homeless youth under 25. We have a staff of 18, 9 of which are lawyers. One of those lawyers is the executive director. One is the one that works with the homeless youth population. And I'll talk a couple of the other lawyers and their dedicated mandates. So we think of ourselves as experts on the legal issues as uniquely experienced by young people themselves. So we're not specialists in that way. So some people can say, I'm an immigration lawyer, I'm a family lawyer, I'm a criminal lawyer. I am all of those things, but only as it pertains to young people. We try to be very selective. We give everyone 30 minutes of free legal advice that calls us. And then we're quite selective about who can become a client, because we do have a limitation on how many clients we can represent. And we try to save those services to young people facing complex legal issues, multiple legal issues, personal issues, and we practice from a trauma-informed, multidisciplinary problem-solving perspective. And in multidisciplinary is a mouthful. We have 2 case managers in our office. Actually, the second case manager starts at March 2nd, so we will have 2 case managers, and they work alongside the lawyers to assist those clients in meeting some of the other social needs that they might have. And that's how we're trying to provide the robust services. So just quickly, sorry, I skipped one. Okay, so we say we have 4 pillars or 4 categories of services, and they are direct client advice and representation. I'll talk a little bit more about that. Community development, so research, collaborations, partnerships like the BAIT partnership that we have that you'll hear more about later. Public legal education, so we have a lot of publications on our website. I've brought a selection on the table there for those of you who want to grab some. We have some workshops and some training similar to CASA, and we work on some law reform initiatives. So that can be policy submissions to the government on legislation that's being passed. Our thoughts on that, and then test cases is a big one. I wrote some examples in there, but Canthasamy is one of them. That went to the Supreme Court of Canada. That was an H&C, humanitarian compassionate application by a young person who was under 18. And the question was, do we apply the same test to their application as we would to an adult? And in the adult world, it was about undue hardship. And what we got out of that case was a discussion around the centrality of best interests of the child and that no young person deserves hardship. So the test is not the same for someone who's under 18, and that's why it's so important if they're close to 18 to get that application in as quickly as possible, because it's going to be time-stamped for their age at the time the application went in. Maze is another test case. Maze was an adult represented by Neighborhood Legal Services. We worked in partnership, and we were asking for a waiver of the citizenship fees. As we talked about earlier, fees are expensive. And this adult woman now had gone through, was in child welfare system her whole childhood, and aged out without any status in Canada. And so by the time she got to that stage where she was trying to get her citizenship, we were asking for reduction in fees or a waiver in fees. So that was an agreement we got. So that's something to know about, that anyone can ask for that waiver in citizenship fees. There's a couple of other examples there. You'll get that, I think. So, we don't just work in the immigration world. Actually, we do lots and lots of other things. So another test case that we're working on right now is a challenge to the voting age, the federal voting age. So we have 12 clients across the country trying to get the voting age lowered. And then the other one that's just happening now is CB. So we'll talk about youth records in a little bit, but the media is trying to get greater access and easier access to youth records. So we're involved in that case as well. So very quickly, you can see I said that we practice lots of different areas of law. That's a little bit of a breakdown from last year. You'll see there that immigration refugee is kind of that yellow one, a bit has a highish number, but that includes the CASA work. So we expect that number might change in the next year since CASA is now its own organization. But you can see education is really high. We get a lot of calls about youth criminal justice work. We have a category called leaving home, which is not actually an area of law. No one's going to say they're a leaving home legal expert, but we categorize it that way because it means that the person's going to have multiple things happening in their lives, and we're just going to address them all in that one category. So you'll be getting their ID, helping with housing, income supports, making sure that they can go to the school of their choice, and that their privacy is protected. So it's a bit blended. As you can see there, we had almost 1,000 young people contacting us, and then when we say we have unique legal issues, when we categorize a young person, if they're coming to us with criminal charges and expulsion from school, they would have 2 separate intakes opened to show that we're helping them on more than one thing. Our client demographics, we started keeping these to kind of figure out what's happening, how we can better meet the needs of our clients. We have found out that 74% of our clients are from a BIPOC population. 50% have experienced some level of homelessness and or violence. 51% have had some involvement with the child welfare system, and 30% are queer identified. In terms of ages, because our clients do this is a capture of a current ages of our clients at that time. So we do have clients who come to us at below 18, but stay with us as clients because their matter is still ongoing past the age of 18. And we have the homeless youth program that goes up to the age of 25. And that also sometimes gets a little older as well because the services haven't ended. So we don't say you've turned 18, we're done. Like, we continue with the file as long as we need to complete it. But under 18, 68% of our clients are under 18, and almost 32% are over 18. We have a couple of specialized programs. CASA used to be on this slide deck. It was very sad to remove them, but very happy that they have their own organization now. So Street Youth Legal Services, just quickly, it's for youth experiencing or at risk of experiencing homelessness. We partner with the GTA drop-ins and youth shelters to provide a lot of the legal services. So last year there was 161 young people, homeless young people that we assisted. We have a program called Your Way Forward for victims of sexual and family violence. It's in partnership with 8 other legal clinics. So this is just our clinic alone. We had 391 cases related to family or sexual violence. This includes exploitation in the sex trade. education support program. So the Toronto Justice Centre in downtown Toronto meets the needs of all the young people who are facing criminal charges. So anyone charged under that, they were under the age of 18 at the time they were charged. They're all at the Justice Centre in Toronto. So we have a lawyer and a social worker in place at the Justice Centre to help make sure that those young people are able to continue school, get access to school, have accommodations met. Sometimes it means changing schools depending on the circumstances of the charges, but that's been key to trying to keep young people who are involved in the criminal justice system also able to continue their education. That lawyer cannot also assist with all those other legal issues, so sometimes that lawyer will what we call refer in to the clinic. So we have like JFCY lawyers sometimes give extra legal services to those young people. So if they're like having trouble with immigration or health or victimization or housing or we might help them out by becoming a JFCY client. The website itself, that's where you're going to find all of our content. There's legal rights information, publications for those of you online. You can download that information. The Your Legal Rights works as a drop-down, open-close Q&A. I think our search function is quite robust. So if there are things that you're having trouble finding on our website, you can always call us and we can try and help guide you to it. But those two that I've circled with the green are the drop-downs that you'll probably be accessing the most. And then there's just some sample content of pictures. I'd like to add pictures to my slides. Intake, for all of you to know, is we try to make it not too lengthy. It's usually the young person who calls and speaks to our intake worker, gets some information, collects those demographics, which is optional, and then a callback will be scheduled with a lawyer. So that lawyer will give 30 minutes, up to 30 minutes of free summary legal advice. Sometimes it goes over. And it's all covered under solicitor-client privilege. And then that lawyer is the decision maker on whether it's going to become a client of the office, or it's going to be a referral, or often they're warm referrals, and other ways to help them figure out what their needs are. Not all young people want to call us and feel comfortable calling us on their own. So if you're working alongside one of those young people, you are able to call on their behalf, be alongside them or for them with their consent, but the arranged callback will require that they be there in the room for that conversation. Okay, I'm going to take a really quick Q&A break if you have any questions about kind of those legal services, legal aid, OCL, anything like that. So I'm going to cover a bunch of topics. We may not have time to cover all those topics, and I can't cover them in depth. So that's all the images you see will be of our various publications. So we have a publication called Your Age in the Law. It covers all sorts of topics. So the first one I want to go to, so healthcare has been covered in quite a bit, so I just like to throw out some other kind of questions. So at what age can a young person consent to healthcare on their own? So feel free to shout it out in the room. If you're online, type it into the chat. At what age do you think a young person can consent to healthcare on their own? I'm hearing 16, some shrugs. Questions? Yeah. That's right. So we have someone in the room who got it right on, and it's not about age, it's about capacity for decision making. So those considerations are exactly that. Do they understand what's going on? Do they understand the benefits of treatment? Do they understand the consequences of their treatment or not having treatment? Yes?
It worked.
So the question for those online is, how are you evaluating whether they have capacity? It's not me making the evaluation. It's the healthcare provider. So the dentist, the therapist, the doctor, they get to make the evaluation. Often in a hospital setting, it might be a social worker or an assessment worker trying to make some of those decisions. And the younger the child is, likely they're going to be there with parents or guardians. or an adult that they trust. And oftentimes in that context, the child is consenting to some involvement of that other human, right? So in my case, and in lots of our cases, if you, like my mom often took me to my doctor's appointments, and as a default, she would be in the room. So it was only later on that I was able to express I'd like to meet on my own, right? So it evolves with age. You're not going to have a 7-year-old asking to go to the dentist by themselves. Likely not. Likely they'll be scared, and they'll want someone with them. So usually the ages where it comes more into play is 13, 14, 15. They're starting to recognize their own bodies, recognize their own needs, want some privacy, to ask some questions without being embarrassed. So that's kind of the context where they're trying to figure it out. But it's the provider, the healthcare provider, who knows this and understands this, and has to make that decision. And the decisions can be challenged. We have a consent and capacity board, and that's where if you do challenge the decision makers, saying that you don't have capacity and looking for your substitute decision maker, then that's the board that it would go to. The next question is, at what age can someone create a power of attorney for healthcare? This one does have an age.
Someone in the chat said 16.
16 is correct. Okay, great work in the chat. You got it. We have a lot of faces in the room saying, oh, we don't know. So there's two kinds of powers of attorney. One's for healthcare and one's for estates, property. It's called power of attorney for property. So some of you may have signed both of these, but power of attorney for healthcare is 16, power of attorney for property is 18. So that's that comes up when we talk to our young people, especially if they're not living with, if they're on their own for whatever reason. I just wanted to flag that IFHP co-payments are coming up. Some of you may already know this, some of you are nodding. So as of May 1st, 2026, IFHP is going to be seeking co-payments. So that could potentially cause a lot of challenges for refugees and refugee applicants seeking health care, because right now there are no co-payments required. So this is the first time co-payments have been required. There may or may not be a court challenge to this. I think there have been discussions in the legal world about whether or not they want to challenge this. And part of it is in 2013, the government did cut IFHP, and there was a successful court challenge to it. So a challenge to this would be similar in nature, challenging the co-payments. I can talk about that with anyone later if they want. I was involved in that challenge at that time. So school, I'm not going to go into everything that CASA's already gone into. I just wanted to flag a couple of other rights that young people have. And healthcare is provincial. So what we just talked about does not apply in other provinces. Other provinces have different ages. Education, again, is provincial. So what happens here may not be happening in Quebec or Alberta or another province. So at what age does a student have a right to see their own Ontario school record? Okay, we have 18, any age, 12, maybe I heard 16, 14. The answer is any age, so they just have to ask. They're not going to get to take it home. None of us will get to take it home. You just get a chance to look at it and see what's in there. It's going to contain disciplinary records. It's going to contain your academic records, as well as any accommodations, special education accommodations that you may have, and an individualized education plan if you have it. That's what's going to be in there. And the next one is around skipping school. When can a young person be charged for skipping school? Truancy. I heard it can't be charged. (12 to 15). They can be charged for skipping school. So we used to be able to quit school at 16. That has changed. So it's 18 now, or if you've graduated, is the age. But in the truancy laws, it always went up to 16, and they didn't change the truancy laws when they changed the education laws, when they changed the age up to 18. So that's what sits there now. I'm not going to cover the current challenges. I think they were well covered by CASA, so I'm going to skip over to the next one. Sexual activity ages of consent. So at what age can a young person consent to sexual activity? So in law. 16, 16, 16, 18? 16? A little bit of agreement, a little bit of discussion, a little bit of questioning. So it is in the criminal code, so it is a criminal offense for the older person if they don't properly ascertain the age of the other person. It's a bit convoluted. So I have a chart. So some people really don't like that 12 is in there, but I'll tell you right now that the old age of consent, when I started practicing law, was a blanket age. There was no in between years. It was 14 and up was open consent. Was the old law. This is the current law. So they've kind of made it more nuanced. So they have a 12 and 13-year-olds have a 2-year gap, 14 and 15-year-olds have up to a 5-year gap, 16 and up, any age. There are exceptions. Person in position of power of authorities, teachers, coaches, as well as there still exist sexual abuse, exploitation laws, pornography, prostitution laws that still impact. So it's not kind of 16 and up is a free-for-all. There's still other laws in place that will kick in. But this was recognized by the government. They did a lot of research. They had a lot of academics and others testify. I was one of those folks that testified around how young people are engaging in sexual activity, what does that mean, and kind of this close in age situation that happens as a natural process, which a lot of the academics spoke to. So we have something specific around intimate images. Can you raise your hands if you've heard this term before in kind of the criminal legal context, intimate images? Okay, a bunch of hands up, some maybes. So this was designed to address the social media harm of sharing intimate images. So the definition comes from the criminal code. Sending messages that are meant to be sexually exciting through text, email, social media, includes pictures and or videos. The intimate image itself is the picture or video created in private circumstances, shows a person who is naked or semi-naked, who is engaged in sexual activity, and that's in the Criminal Code of Canada, Section 162. Adults over the age of 18 are allowed to take, send, etc., intimate images. To share those intimate images, consent is required. So I can share my image with Sarah. Sarah would have to get permission from me to share it with Esther. So that's how, because we're over 18. There's special rules if you're under 18, because all those images, if they're under 18, is considered child pornography. So they've created a couple of exceptions for young people who are engaging in sexual activity with a partner, an intimate partner. It's for private use, can't be shared, it has to be kept private. You can't print, can't publish, can't share, cannot consent to having that shared. So that the law doesn't allow that sharing. When it is shared, then it's going to be considered sharing of child pornography, which will be captured under these other laws. Leaving home, that was also touched upon. I don't know if we talked about the age, though. At what age in Ontario can a young person withdraw from parental control? 16? I'm hearing murmurs. 15? Maybe I heard 15, 16. Some nodding. 16 online. 18. Some folks want them to be so old. So in Ontario, it's 16. It is 16. Obviously, it's not going to be an easy life to be leaving home at 16, but it does mean that some young people do it, well, some people are kicked out, and some people do it because of safety and security in the house, are the primary reasons that we hear about it. This is provincial. So we have had situations where a young person withdraws from parental control here, and then they change provinces, and then we might get a call from like the principal of a new school in another province because they're asking about why this young person was able to go to school in Ontario without their parents really knowing what was happening. So we have had to have some of those conversations. Can they take their ID and belongings? Yes, lots of nods. I haven't heard a no yet. There could be a no in there, but I didn't hear it. So yes, they can take their ID and belongings. And does this impact going to school? Maybe, right? That was raised by the CASA scenario where, what if they move? What if they're in a different jurisdiction? The other part of that is they can ask for privacy. They can ask the school to no longer share their information with their parents or guardians. Because they've withdrawn, they're considered independent. They do not have to share that information with the parents and guardians after that. I'm running, no, I still have time. So leaving home and child welfare, we have a question. So the question from Sarah is, to leave home, do you have to do something? So yes, you have to leave. You have to leave and make the declaration to someone in the world. You don't have to say, I'm withdrawing from parental control, but you have to take the steps to become independent. So you are responsible for your housing, when you were going to school, working, your living circumstances, how you are feeding yourselves, healthcare decisions, et cetera, et cetera. So you are, when I turned 18, I effectively became an adult, but I still spoke to my family about my decisions. So it's not that they're not allowed to speak with people about their decisions, but they're saying that I am now going to take care of myself for the most part, and I don't want to be controlled by my parents and guardians. So there is a template letter on our website that speaks to the school situation specifically. That is just a letter saying to the school, dear principal, I have withdrawn from parental control. Please don't share my information. This is the authority that lets me withdraw from parental control. And there have been challenges in the past over this age. And things that we have done to help support young people at this age, and we have won in all of those circumstances. This age has been upheld by our courts up to the Court of Appeal quite recently in a challenge that we were facing, so that young person did get to make their own decisions at 16. Did that answer your question? Okay, visas, that was mentioned in, oh, sorry, that's the next slide. Okay, leaving home and child welfare. I'm seeing two slides on my screen. So at what age can a child be removed and taken to a safe place or brought into the care of a Children's Aid Society if there are concerns about their safety at home? Any age, that has come out loud and clear in this room, hopefully online as well. So you're right, at any age. So that's due to reporting. And then what happens specifically, though, if they're 16 or 17? They can receive welfare is one of the answers. Yes, so that is it. I'm going to go to the next slide to explain it a little bit more. But yeah, so 16 and 17-year-olds cannot be removed and taken to a place of safety by CAS on their own. So CAS will not just come and take a 16-year-old out of the house. A 16 or 17-year-old can approach CAS, or if they're called for whatever reason and they do show up, to discuss whether they want to enter into services with a CAS. So those are voluntary. So when they're 15 and under, it's not voluntary. Often there will be a court proceeding that is involved. The OCL will be involved. The parents and guardians will get if they don't have a lawyer, will get a legal aid certificate to represent them in that family law case. But if they're 16 and 17, so previously, maybe I should have written down the years, I can't remember. So previously, if you were 16, so CAS could not get involved. They could not provide services. So this is new-ish in my world. I've been practicing at the clinic since 2003. So in my world, this is new-ish. Voluntary youth service agreements are now available to 16 and 17-year-olds with CAS. So so they're living independently, but they get some support. They get some financial support. There's a worker involved that helps them with a number of things. Sometimes they've helped pay some of the fees for ID replacement, some of the fees that might be required, first and last month's rent, et cetera, et cetera. So there's lots of things that they can provide. Visa agreements are maximum 1 year at a time. Sometimes they're shorter and they get renewed. And if they're at the day they turn 18, they're still under a visa or the visa ended on that day, then they are qualified for the Ready, Set, Go program. And the Ready, Set, Go program gives extended services to that young person. So it can assist them in staying in their apartment, assist them with school fees, et cetera, et cetera. So there's a number of things that come in there. And the whole idea of the program is to assist that young person well before they turn 18 on what it means to be living completely independently with no child welfare services in place. So that's part of it. And one of the things that is in there is some discussion around status. So there's been situations in the past where young people have been involved with child welfare and have turned 18 without any steps taken to secure status in Canada. So there's some lists in there of things, but also like helping them budget, helping for financial independence. So there's a number of things in there. So we have two different, so again, like I said, these are all like information and booklets that we have on our website. Okay. I want to cover as well. So I'm going to do this super quick because I do want to get to youth records because I think they're really important for the precarious immigration status situation. So when can police ask questions to a young person without their parents' consent or presence? I'm just going to answer that. It's at any age. If they are charged, they do have a right to have a lawyer and a right to have an adult present. So any of us, if we're charged, we have a right to a lawyer. We do not have a right to have an adult with us unless we're under 18. And the second one I will ask you is, when can a young person be charged for a criminal offense? What's the youngest age? I hear 12, 14, 13. And this is Canadian law, so the Youth Criminal Justice Act applies. The Youth Criminal Justice Act only allows a young person 12 and up to be charged. So 12 is and it's the day that the offense took place is the age they're looking at. And you stay in the youth criminal justice system throughout that period of time. If you were charged for an offense that occurred when you were under 18, when you were between 12 and 17, then you stay in the youth justice system. Youth records. So this is an important distinction, and it's important as well for the immigration context. Youth records and adult records are very different. So youth records contains information about outstanding charges, things that are going through the court system, findings of guilt, discharges, any conditions that might still exist while they're on probation, and arrest warrants. Adult records, the biggest difference with the adult records is that adult records are called criminal records. Youth records are called youth records. They don't have the criminal in there. So they're called youth records versus criminal records. The other one is, earlier I said, youth records contain findings of guilt. So young people are found guilty, adults are convicted. So young people do not get convicted. They are found guilty. The language is really important because you'll see it in questions like, have you been convicted for a crime for which you have not been pardoned? If the offense took place when they were under 18, The answer most likely is going to be no, you have not been convicted. And you won't have a criminal record. So sealing. So we call them sealing, destruction. Lots of places will destroy them, but we call it sealing because once it's sealed, it can't be used again. So whether it physically has not been destroyed, it still means it can't come up. So when does that youth record get sealed? No criminal law experts in the room. Okay. So I have a slide on the next one on when they get sealed, but I do want to say that a youth record can become a part of the adult record if the young person's given an adult sentence. Okay, so that's a big one. You stay in the youth court system for very serious violent offenses, a young person can be given an adult sentence. If they're given an adult sentence, then they've been convicted and they have an adult criminal record. The other one is if they commit another crime after turning 18 and the record has not been sealed. So I'm going to give some examples on that. So records are not sealed at 18. It depends on what happens in the court system. If they're diverted with EJS, they'll last for 2 years. If they're found not guilty, they'll be sealed after 2 months or a deadline for an appeal has passed. If the charges are dismissed or withdrawn and you get a reprimand, it's 2 months. Charges are stayed 1 year, absolute discharge 1 year, conditional discharge 3 years. These are not the ones that most people are worried about. Because in the circumstances where lots of these have happened, odds are, based on stats, is that young person is not going to be in the justice system again. It's what the statistics all say is like rehabilitation is high with young offenders. So what comes up more importantly is if they are found guilty, then this is the important years. 3 years from the end of the sentence or 5 years from the end of the sentence. So whether it's a summary offense or an indictable offense will be listed in the Criminal Code of Canada. Sometimes it's listed as a hybrid offense, which means the Crown gets to choose whether they proceed as a summary offense or proceed as an indictable. And they will know that how they choose will impact the end date of when that record is going to get sealed. So for more serious crimes, they're going to elect indictable. For less serious crimes, they may go for summary, and then sometimes the defense can kind of lobby for that summary offense designation instead. But this is where an example might help a lot. So say I am 15 years old and I'm charged with something quite serious, and I go to court, I'm found guilty, I have a trial, I'm found guilty, but by that time that happens, I'm now 16. 16, I'm found guilty. I'm given a 2-year sentence. So I'm 18 when I finish my sentence, and it was serious. So chances are it's indictable. So if I'm 18, when will my record be sealed? Right? 23. That's a long time. So if that young person commits a crime while they're waiting for these 5 years to end, and they're convicted of it, that youth record becomes part of the adult record and does not get sealed. If they commit a crime at 24 and this has been sealed, it's gone. It can't be brought up in court. It can't be raised again. Same with if they're 35 or 45. Once the youth record is sealed, it's over. So that's that's really important. If you're found guilty of another offense, the time clicks again. So sometimes, say I was 16, 17, out on probation, I committed another crime, I'm still under the youth criminal justice system. So then I will have this start time. Whatsoever the latest date is when it's going to end. Chances are my second crime's not as serious, so I'm probably still waiting till 23. The big one is around immigration inadmissibility. For youth records, YCJ charges, findings of guilt, it should not impact immigration admissibility. It can extend some wait periods, and it can cause significant complications for travel. But at the end of the day, if it's sealed, it should not impact the admissibility for immigration applications. What we do see more of is around access and privacy. This is really significant. There's a lot of rules around who can access the records and the privacy rights of the young person. There's strict limitations on who can see those records. There's a list. That's Section 119 of the YCJA. It lists all of the people who have access to those records. This is where I said there was a court challenge. CBC and other media outlets are seeking to be added to this list. So that just went to a hearing on the 8th and 9th, so we're waiting for a decision. I think either way it's going to get appealed, so this will be going through the court system for a while. But just because the person had access doesn't mean they can share that information. So that list of people, like the lawyers, like the parents, like the adult assisting, like the police and the judges, they have access, but they can't share it. The only time that information can be shared is specific authorization in the code, the YCJ itself, or by a court order. So that's where the media is challenging. The media has had to go to court to get access to records, and they don't want to have to do that. And the reason, and this has everything to do with the preamble, has everything to go back to the UNCRC that I mentioned at the beginning. In the YCJ preamble, it talks about the UNCRC and all the rights of young people. So youth are presumed to have a reduced moral culpability, they have increased vulnerabilities, decreased level of maturity, increased capacity for rehabilitation. And privacy itself is critical to promoting that rehabilitation and reintegration. These are all the reasons that privacy, access, and disclosure are restricted. Really narrow grounds for permitting disclosures. A police officer, Crown attorney, or youth worker may disclose limited information if necessary to ensure compliance, to ensure safety, to facilitate rehabilitation. So my example there is a school might be told about a condition to remain apart from another student to ensure compliance. So they may still be in the same school, but this way they won't be in the same classroom. So they'll have to set up some rules and guidelines and boundaries on that. And not everyone in the school has a right to know this, right? Everyone who needs to know this, anyone who's setting out the schedules, might need to know this, but they can't share it with all the other teachers and all the other students. There is a limitation on that. And then the court orders is what you can get. You can seek information. I just want to pause there for a moment. YCJ is really complicated. And there are a lot of adult criminal lawyers who don't practice in youth matters for that reason, and some practice in both, and some practice only in youth matters. So it's a very narrow and specific area of law. So that's where we really do encourage people to call us to find out information. We have adults who call us to ask about their records because they're unsure, they're not clear, they don't have all the information. So they're seeking some guidance about what happens, because it may have happened a long time ago, they remember a little bit but not a lot, and then they're just trying to help figure it out. So we do help a lot of people navigate that, and we have a lot of information on our website about that. So I just want to iterate that the criminal system is unique when it comes to young people. Okay. I have more slides around name changes and human rights and LGBTQ2S rights. I'm going to skip through all of that. They are in our publications. There's a copy, I think, of the LGBTQ one on the over there on the table, but they're all on our website. And the reason I want to skip over some of these is to kind of get to, alcohol, cannabis, it's 19, it's provincial, so it's different in different provinces. So cannabis might come up in some questions. We get a lot of questions about cannabis. So the big one is In Ontario and most other provinces, it's 19. In Alberta, it's 18. In Quebec, it's 21 for cannabis. And we have a infographic on that. But what I wanted to leave time for is questions, and questions for me, questions for CASA that might come up. We ran out of time earlier, so I'll make sure we have time now.
We have several questions from the chat. The first is, what is the confidentiality guidelines for healthcare workers when treating kids on their own? If a younger child, for example, 10 or 11 years old, discloses something like drug/alcohol use to a physician, are they required to inform guardians?
So in general, under healthcare, there is a high level of confidentiality required, but under the CYFSA, there's also some requirements. And the duty to report is something you've probably talked about yourselves, the duty to report, and that's to child welfare. So it's not necessarily a duty to report to the parents or guardians. That's going to be about whether they have the capacity to be seeking these services on their own and whether a substitute decision maker is required. But in terms of, there is no written duty about when the parents and guardians have to be notified about these things. But obviously that, the age that was stated was 10 or 11. That's quite young, right? So odds are that a 10 or 11-year-old is not seeking healthcare on their own. It may be with another adult that's going to be informed about what's happening, but it's pretty hard for, how many young people will have access to their OHIP cards? They're usually not held by the young person. So the reality of them being that young is kind of low. I'm not saying it never happens, especially maybe around cannabis. Access in the school system, there's lots of it, so it might happen, but the duty to report goes back to child welfare.
Right. Next question is, how has CAS adjusted around the Brandon case of years of systemic failures and neglect, as well as other CAS scandals in recent years, racial profiling, financial misconduct, foster care abuse, etc.?
So this is specific CAS's Children's Aid of Toronto, Children's Aid Societies of Toronto. Is that how it's written out there? CAST? Oh, CAS itself? Okay. Yeah, there's been a lot of challenges. We are not part of CAS. Actually, we've probably been a part of some of those challenges, stating that they fail to meet the needs of young people. So I can't really speak to their responses per se, other than to say that there are new guidelines, there are pushes. The Ready, Set, Go program was a response to some of the needs of young people. Putting in visas being available for young people is another response that was sought because of the young people who are needing services at 16, 17. So I can speak to how the legal system has responded. Those are the online questions? So the question, I don't know if it went through the mic, so will we, JFCY, support someone who was under 18 at the time of the alleged crime, charged under the YCJA, but are now over 18? So at the very least, we would give them the 30 minutes of summary legal advice, and depending on their entire circumstances, we may represent them, but it will depend on the circumstances. Okay, those are all the online questions. Are there any questions in this room for me or for Esther or Sarah? Okay, are Esther and Sarah, I see Sarah, where's Esther?
So the question was, what can be done for people who are under 18 who are trying to renew a permanent resident card but don't have a parent or guardian to sign the application? I would say they should contact us or a legal clinic and speak to a lawyer. This is, I was actually just looking at this online yesterday, and the PR card application form states very clearly that if you're under 18, I think it says if you're under 14, your parents or guardian has to sign it and the young person doesn't sign. And if you're 15 to 17, both the young person applying and the parent are supposed to sign. And that's an example of what we were talking about, of the immigration system really not contemplating a young person who's trying to do this on their own, for any reason, whether because their parents aren't here, whether their parents are refusing to sign, and so that young person needs legal support because they have a right to renew their PR card, and they're facing a government-imposed barrier that I don't know if either of you, Sarah, if you want to speak about. I suspect that that's not something that they're going to resolve on their own just by submitting the application with like a letter or something like that. It will probably require more concerted advocacy up to the, there would be intermediate steps, but up to the point of litigating where you challenge the government to say, like, you're denying this person the right to their PR card, and I suspect the government doesn't actually want to litigate that. So that would sort of be the ultimate route. Could be.
I agree. And I also, it's helpful to know that there's a ton of inconsistencies in immigration forms and policies, particularly around age. So some of the two, on this point, Esther's talking about ages to do your own PR card. But we've also seen over recent years, there's a document called a use of representative, which is a document that someone would sign and submit to immigration to say, this lawyer is my person, contact my person, they're the one representing me. And over recent years, we've seen a little bit be added to that says if you're under 18, your parent or guardian has to sign that form. That is new, and that's not, we don't agree with that. We think that young people are entitled to lawyers, and that this is just another way of the government sort of restricting young people's access. So I think it's helpful to know that all of those bits, if you get to that point and you're like, this form says this young person can't do it by themselves, it's worth thinking about it, and it's worth thinking maybe I need to get legal advice about this. The other piece that is super annoying about this is as soon as you turn 16 in Canada and you're a citizen and you're applying for your passport, only the young person can apply for their passport. An adult cannot apply for the passport. So even within the immigration system itself, they've got all these different ages and they're treating people differently, seemingly for no good reason. So it's always worth questioning.
Yeah, and these rules and age requirements, different age requirements that they're putting on, saying that, at certain ages your parent has to sign, those are generally not coming from the law or the regulations. Those are effectively policy decisions that someone at the immigration department has decided. And so that's why there's often, with legal advocacy, there's often, we can often get around these because ultimately they're not coming from the law, if that makes sense. Were there any other questions that? There are plenty of questions. Sure. I think we could, maybe we'll hear one or two. Do you want to give us one or two more and we'll. So can we elaborate on fee exemptions for people who are here on expired visitor permits? So I assume that the person is talking about school fees, like for elementary or secondary school. Post-secondary fees would be a whole different sort of kettle of fish, and I think when the BAIT program presents, they're going to talk about post-secondary access. So people who are here with valid visitor status under the Education Act are supposed to be required to pay school fees. If you are if your visitor status has expired and you are here without status, then that section of the Education Act that we showed, 49.1, says that people who are under 18 who are here without status are supposed to be allowed to go to school. But we see, Stefan is nodding his head, we see challenges to this around what happens if somebody is in school but they're turning 18 and they're not graduated yet. We are also seeing challenges around people who are here under 18 without a parent or guardian and are being told that they need a court order to say that the family friend they're living with or the children refugee shelter that they live in or the aunt who they are staying with is their legal guardian. So there are lots of challenges, but in theory, somebody who is here whose visitor status has expired should be allowed to attend school and fee exempt.
Awesome. Is there funding available for those who cannot afford immigration application fees? Who they say can't afford?
I read that question and I assume it means, is there funding for people who cannot afford?
Yep, that's what I was thinking too.
Yes, there's funding for people who can afford them. That's called they pay them themselves. So as we mentioned and as Sarah talked about, it is often very challenging. As I mentioned before, I was just looking about PR card renewals. There's a $30 fee. The client that we're talking to about renewing her PR card almost certainly doesn't have $30. CASA sometimes is able to come up with money to support our clients. There are different, we were talking with a sort of a social work type person recently who was trying to see if OW, her client is on OW, if there was any sort of emergency funding through that. I would encourage everybody watching today to think about whether that's something their agency could direct any funding towards, to pay application fees for people who really have no option. It's not, for many of our clients, for many people, it's not a matter of saving a few dollars to get to paying that application fee, that the fee is going to be prohibitive. And so I don't have a real sort of slam dunk answer that, there's this, magic pot of money that anybody who can't pay can access. I think it is, in some regards, up to the community. And I've often seen people being supported by their own community, like not necessarily by this sort of settlement community, but actually by their own, whether it's religious, whether it's ethno-linguistic community, family, extended family. But yeah, also encourage everybody to think about whether that's something that their organization can devote any funds to. Are you, in our case, one of the things that we use honorariums from events like this for is to contribute to a fund like that.
I agree. I'd love there to be a fund. I don't know of one. I think if a young person is working with the Children's Aid Society, either on a visa or in some other ways, we can usually get that CAS to cover those fees. Sometimes, and depending on what a young person's relationship is like with school, maybe they've got really strong supports there and they know about the immigration status. Maybe they can help them access fees or some kinds of fees, but it's super challenging. There's so much money, and I think one of the problems is, I think if a young person hears that first, they don't even ask the questions about anything else. So I usually say, there's some fees, we're going to talk about them later, let's actually figure out what's going on first and then come up with a plan. But I also agree with Esther's point, we don't want that to surprise them later on when they're halfway down the track. So it's hard. I think the government should get rid of all those fees. They've been talking about getting rid of these fees for citizenship sort of things for a long time, and it hasn't happened. But it's a really good way of keeping a lid on who gets to apply. And
I would also, just to say one more thing. I would also encourage everyone, when you're working with young people, to be a bit of an advocate for them. Can you talk to? Are they involved with any social service agency, other agencies, whether it's community health centers or other groups, and that young person might not be willing to ask for money, but if you are the one who's contacting, another organization or professionals to say, hey, do you guys have any money available for this? Sometimes there are funds. We're always hearing about different little pots of money that are not. These are not things that are advertised. They're not going to be on people's website, but there are sometimes resources available.
And if I can just jump in quickly about the legal clinics. The legal clinics do have access to what we call legal disbursements funds. So we do have, all the clinics have access to some of these pockets of money as well to cover some of those. And our clinic has a special fund that's specifically through private donations that we save up, and that's how we use those funds as well.
Okay. So I think we're going to eat lunch now, right, Tarana? Is that what you're coming to tell everybody?
No, that's and more. Thank you very much for all the conversation. And I can say we already have a subject, or we already have an idea for our next event. Online participant, thank you very much for the questions. Please fill in the evaluation form. Tell us the ideas. Maybe next time we can do webinar. And reply all your questions and invite more speakers from legal clinics or children aid society and have another session. But I would like to acknowledge Emily's presentation.